Good morning, everybody. Appreciate you joining to our latest edition of our established ESOP panel. We are very excited about today's panel discussion. Over the last couple meetings, we've tackled some cool concepts, things for more mature ESOP companies to think about. We've tackled repurchase obligation and some other hot topics. And in this specific meeting, we're going to be talking about the Department of Labor and regulatory hot topics. Always think that it's prudent and responsible for the ESOP-owned companies to stay up to date on what's out there in the regulatory environment from perspectives as a trustee or from a corporate governance perspective, as well as on the valuation side. And so very excited about our panel today, who's going to be tackling some topics about what they see, what they hear on the DOL front. We'll start off and then have each individual introduce themselves as they speak. As always, feel free to leave questions in the chat box. I will see them, or Danny will help me, and we'll make sure that we see them and respond to them. But really excited to talk today. It's, again, always good to know what's happening in the regulatory environment because, ESOP companies, we are regulated, right? So we want to stay ahead of that, whether that's individually, whether that's your executive team, or maybe that's your ESOP administrative committee. So to kick things off, thought I would turn it over to Jeff to talk a little bit about, from his perspective, how ESOP companies tend to properly monitor or what best practices are to stay abreast at what's out there in the regulatory space. Jeff, why don't I turn it over to you?
Sure. Thanks, Josh. Appreciate it. So obviously now I'm working for Lazier Capital, providing post-transaction consulting services. But prior to that, I ran an ESOP company for a number of years, almost 10 years. And, we became an ESOP in 2014 in an era when the Great Bank Settlement was looming and the Department of Labor was in the forefront of everybody's mind. As a matter of fact, and we had always been advised by the trustee and other professionals we were working with that as an ESOP we could expect that we would be audited by the DOL in the first 5 years of our existence. Now, turned out we were at the tail end of that era, and we never did get audited, but very much we had the regulatory issues in focus, and we're very careful, both as a management team and as a board, to make sure that we were doing all the things that we needed to do and doing them properly, but in addition, also documenting what we were doing and why we were doing it, so that we had the appropriate support if that need ever arose. And so, how did we stay abreast of that? It was really a combination of things. One was attending conferences, right, and going to different events, hearing breakout sessions. Oftentimes there were former DOL or IRS folks that did these presentations and told us what the departments were thinking and what we should be aware of. In addition, always staying in contact with our trustee, certainly with our ESOP attorney and other professionals in the industry, helped us stay up to date with what we needed to be aware of and what potential issues were facing us. So that was really our approach. We were very diligent about it, and I think that although we never ended up being audited, it still paid dividends. It helped us from a corporate governance standpoint, even just have better practices and be more focused about what we were doing and how we were doing it. So that was really our approach, Josh.
And Jeff, I guess I'm curious, did you work with, in-house attorneys? Did you have a separate administrative committee that sort of had a task to look out there at the regulatory environment or attend things? How did you tackle that?
Great question. So we used an external ESOP attorney. We didn't really have the in-house expertise. We just weren't large enough to have that. But we had great outside counsel that was very on top of all the issues and very aware. I mean, it's all they did all day was work on ERISA related programs, and so we could rely on them quite a bit. And we did have an ESOP administrative committee, and that was part of their task, was to make sure that we were staying on top of all the duties and responsibilities we had to the participants, to make sure that we were meeting any regulatory requirements, making sure that the 5500 was getting filed every year on a timely basis, making sure that it was accurate, making sure that people were, terminated participants were being paid in a timely fashion, that people were receiving their statements in a timely fashion, et cetera, et cetera. But yes, that committee really took on a very important role, and we had named that committee as our ESOP plan administrator, which I know sometimes gets missed by boards, especially early on in an ESOP environment. And naming them made sure that we identified that they were the folks that were responsible for doing that. Not that as a board we still certainly had fiduciary liability and responsibility for all of those things, but we did have a group in place that was monitoring that on a regular basis.
Thanks, Jeff.
Yep.
And as we proceed, I'll go ahead and introduce the rest of the members of the panel that you see here, as they'll be maybe chiming in over top of each other as we continue the dialogue here. So you have Brian Nemag. Brian is a founding partner of Vision ESOP, evaluation firm out of Michigan. You have Avery Chenin, who is an attorney with SCJ Consulting, an independent trustee firm. And you have Steve Goodman from Lynch, Cox, Gilman, and Goodman. Steve is an attorney who has sat on all sides of the table many times, the company side, the trustee side, and the bank side, and has good perspective. So those three are going to start chiming in now as we actually start to hear about what we've been hearing and seeing on the DOL front more specifically. So maybe we can tackle kind of one of the first topics that I know has come up, and that relates to trustee indemnifications and what we've seen sort of pop up over the last few years as it relates to what trustees are wanting to see and how indemnification works between the ESOP company and the trustee, not only just on the onset of the transaction, but certainly post-close. Maybe I'll turn it over to Steve to start, and Avery and others feel free to chime in as needed.
Great. Thank you, Josh. I appreciate it. Yeah, as you know, when a trustee gets engaged by a company, they generally have an indemnification provision included in the agreement. And a lot of times that indemnification agreement can be limited so that it excludes breaches of fiduciary duty, intentional acts, those types of things. But generally, the trustee wants the company to say, if something happens and they get pulled in and it doesn't violate the fiduciary duties to be indemnified, that they want the company to come back and indemnify them. Well, and again, an indemnity is a situation where the company would an indemnity is a situation where someone indemnifies someone else for a breach of their duties. And ERISA specifically permits, ERISA Section 410 provides that a plan and a plan sponsor cannot indemnify someone for a breach of their fiduciary duty, but allows them to indemnify for other types of actions that they get pulled into. Also, ERISA 410 allows insurance coverages for the breaches of these duties. Well, what's happened over recent years is there's kind of a split in court decisions on whether a company can pay this type of indemnification. And the idea is that if the company, one group of cases comes back and says, hey, a company cannot indemnify if it would reduce the value of the stock to the ESOP participants. And the other line of cases go the other way and say that the assets of the company are not a plan asset, and therefore the company can provide this type of indemnification. The Department of Labor, when they, as you are aware, the Department of Labor has recently started handling fiduciary matters with settlement agreements. And one of the first ones was the Great Bank settlement agreement. And it specifically provided that the indemnification is permitted because the assets of the company were not a plan asset. Well, the DOL quickly changed their mind. And they're basically saying that ESOPs and ESOP companies cannot indemnify trustees for breaches, especially for their fiduciary duties. What's interesting is that on audits that we've had several audits, and the Department of Labor is asking for copies of the engagement letters of trustees. And if they see that there's a indemnification in there, the Department of Labor will send the trustee and send the company a notice that they think that this violates ERISA, and warns them not to utilize this indemnification provision. And so it's put us in kind of a quandary because Avery is. Let me ask you, how do you guys handle it? In terms of, one question is there really a downside to providing, these indemnifications?
Well, Steve, I think you raise a good point, and thank you very much for pointing that out. So I am actually a recovering ESOP attorney, but I'm working for a group of individual trustees. And the way that we view this is that we should cover all bases, which means that in our engagement agreements, we do provide for indemnification provisions. However, we also require fiduciary insurance to cover not only the board, but to also include the trustee. As Steve pointed out earlier, Section 410B of ERISA permits a company to insure a fiduciary for breaches of fiduciary actions. Naturally, that makes us feel comfortable, but it also helps the company and the participants because, okay, where do individual trustees fall out on this? Individual trustees fall out on the side of, geez, one, you want individual trustees to trust your plan, and the way that you get to do that is through indemnification or insurance. The second issue also is that actually fiduciary insurance and also indemnification provisions are protective of the plan and its assets. Because the truth is that along with the Department of Labor works in a very subjective atmosphere. There are often questions related to valuations. And I've been through a number of DOL investigations where after the DOL claimed that there were issues in relationship to the valuations, they backed off of the valuation after we demonstrated that the valuation was pursuant to ERISA. So the way that we view this, Steve, is that we have indemnification provisions in our engagement letters, and we also require insurance. And effectively what we're doing is that we're covering all bases to protect the client, the participants in the ESOP.
But Avery, it's interesting because what do you do? Say you're a plan sponsor, and you receive a letter from the Department of Labor saying, we think this provision is unenforceable, and if you reimburse the trustee, you're violating ERISA. Now they've contractually agreed to indemnify you in your engagement letter.
Right.
So they're in a quandary.
I think I think the best approach would be to work with the company in relationship to that, because ultimately, although the department can say that that is their position, that position isn't ironclad. There can be discussions with the Department of Labor. And second of all, if the company is not indemnifying the trustee yet, there has been no violation.
Right.
The other point in relationship to this is that I know that there's been court cases, but mostly the guidance comes out of settlement agreements. Settlement agreements are great guidance, but they only apply to the company and or ESOP that the settlement and the trustee that the settlement agreement has been negotiated with. So it's not hard case law. As you pointed out, though, there are cases on both sides as to whether indemnification is enforceable or not.
You know, the other thing too is that if you can't have an indemnification standard
Mm-hmm.
built into your agreements, it would tend to cost more to either get a trustee. You may not even be able to find a trustee,
Mm-hmm.
which could result in there being possibly fewer ESOPs outstanding.
That's
It
exactly
could also
right.
be it could also be a boon for the insurance industry because everybody will get insurance policies.
Well, well, number one, it already is a boon for the insurance industry. But the other thing that everyone should remember is that across the board, all individual trustees have a gross negligence, willful misconduct standard in their indemnification. So if a trustee goes out and acts grossly negligent or acts as willful misconduct in regard to a plan or breaches their fiduciary duty, there's no indemnification requirement anyway.
So I guess to close the loop on this one before we move to another topic, Steve or Avery, any overall recommendations for ESOP companies? Is there maybe going back and now saying, hey, I need to look at my contract with my trustee and see what I see in there?
You know, when we meet with the clients and, and we explain to them that there's an issue here on the fiduciary coverage side, but it really hasn't prevented anyone from moving forward. I think that we're seeing this inside all of our trustee agreements and engagement letters. I don't see any reason not to keep moving forward.
Yeah.
Yeah. And Josh, just as an add-on to that, again, trustee's position and helpful to the company and the ESOPs is cover all your bases, right? And, and then if there are issues, those issues can be discussed with the Department of Labor.
Perfect. Thanks, Avery and Steve. Let's move on to a little bit of a different topic, get Brian involved here. One of the things that I know that there's always a lot of question about are yearly projections. Obviously, you all as ESOP companies are getting your stock valued once a year. And as part of that, you are likely putting 5-year projections together so that the valuation firm can get a sense of, not only where the company has been, but where it's going. Brian, maybe happy to turn it over to you to kick off kind of what you're seeing in the day-to-day as you do these yearly updates and look at kind of what's been going on in the industry.
Absolutely. Yeah, thank you, Josh. So I'm Brian DeMag from Vision ESOP, 20 years in this space. So definitely seen a lot of different sets of projections and how those projections impact value and also are used against the companies in litigation. So typically when we're looking at projection risk, we think about it, in the initial transaction. But since they're all, ongoing mature ESOPs today, we're going to talk more about projection risk as it relates to existing ESOPs. So we're not going to talk about the front end, but still very, very important to document and go through a great process on the projections. So with each company, we do ask for, and most appraisers do ask for a 5-year detailed projection. So income statement, balance sheet, cash flow to understand what the company thinks the most likely outlook is. That's very important that we discuss that, when we start working with ESOP companies to tell them what types of projections we're looking for. There's various different sets of projections that our companies might have. Some would be for kind of sales team projections, which we call maybe there's a little bit of a stretch goal embedded there. We also have companies that would have kind of a break-even analysis, basically saying here's our a budget of what we need to make in order to make payroll, things like that. We're not looking for either of those. We're not looking for the most conservative or the most aggressive. We're looking for the best guess, what the company thinks is the most likely scenario. And that's very important because if there's any Department of Labor or non-ESOP litigation that's going on, those projections tend to get a big highlight on them and challenged and kind of dug into pretty deep by the outside parties. And what they're looking for is any kind of bias in those projections. So, of course, on the front end, again, we won't talk a lot about it, but the Department of Labor would typically come in and say, hey, we think the valuation is too high because these projections were inflated. There is just as much risk we've seen on the back end with existing ESOP companies if the projections are too conservative. So what happens there is if the company does go through and has obviously conservative projections, of course, the valuation firm needs to challenge that, to assess risk. That's our role. Our job is to say how risky or aggressive do we think those projections are. But we do need to challenge those. But at times, companies will still say, "Hey, this is what we think is, our projection set, and we think they are conservative." The risk with conservative projections is when you get towards either the sale of the ESOP. So let's say it's an internal buyout. There's definitely risk there if we're looking at more conservative projections, and more increasingly, we're seeing non-DOL litigation. So participants who have been fired or have left the business potentially have relatives that my brother-in-law works in Wall Street and he thinks that my stock should be worth more. Those types of questions. That's where you're seeing those projections being challenged on, I would say, for existing ESOP companies. And so what we really want the companies to focus on is looking at industry sources, looking at projections for public companies. Every public company has analysts that follow it and will come up with their own projections. Now, those tend to be, pretty high growth, pretty aggressive projections, but at least it's a data point in the market to look at. Of course, almost all of our companies we work with are involved in some industry associations and get different sets of forecasts and outlooks from those associations. Those are great resources to tie into your projections to see if you're, within range of the industry. And then we ask the companies to, each year, as we do, we look back and compare how did you perform versus your projection, and why did you hit or miss those projections. Each year when we ask for projections, we tell the company we know you're not going to hit this. You're going to be higher or lower, but we just want your best guess. And then each year we want to try to add on and improve those projections by seeing what worked, what didn't work. When we're giving advice on projections, if we are to try to help the company develop those, one thing we do look at is historic growth rates. And we call it compound average growth rate, and so it's your annual growth over time. So, for example, we could have, if we're helping or discussing a projection with a client, saying, "Hey, look at your compound average growth rate in revenue or earnings over the last 5 years. If your growth rate's 8%, maybe use that as a baseline for your future." Now, of course, if there's a lost client or a lost salesperson or litigation or anything there that would throw you off from that, then you document that, explain the reasoning why, and adjust appropriately. On the flip side, yes, if you've landed a new contract or you've entered a new market or a recent acquisition, well, then there'd be a reason to have higher projections than that history. But what we don't want to see is a historic trend of 3% growth and then projections of 10, or on the flip side, historic growth of 10%, and now we're getting too conservative and saying, hey, just 3% growth. So, the projections, of course, can be wildly different than history with good reasons, but the important thing is there are good reasons, and that's documented. because that's really what would help in any type of litigation on the back end, is the documentation, the process that you went through. So, involving multiple people in that process, not just the CFO, CEO, but talking to sales teams, talking to project managers, talking to the customers when they give some types of forecasts, to really build that up and document that. And like anything, that's, you're going to hear it from Avery and Steve for sure. From the legal side of it, it's documentation and process is almost more important than the actual numbers in those projections. The
You're
DOL,
right.
of course, does like hindsight 2020, but I think the process itself really goes a long way. Is even if the projections don't, play out as planned, which is very common, you can look back and say, well, we projected similar growth rates as the industry, similar to our history, and therefore not having those types of kind of holes in your analysis.
Yeah, Brian, I think you're right. We see it when our clients get audited. One of the first things the DOL looks at is that, they want to know the projections, who did them. We find ourselves scrambling trying to get that type of information, and because different valuation firms have retain it and use the materials different ways, but they're really into the independence of the person who's prepared it and what is their background. Do they have the background in which to analyze the numbers and everything, and do they have independence? Do they have any relationship with the company? It's very much like they're retaining another valuation firm, but we're always, and the other thing too is what's hard is that, we're representing the company and the ESOP and the audit, the trustee, and we're trying to defend somebody else's work. Somebody who 2 years before, 3 years before, started doing the valuations, and, how do they get there? And so I think you're right. Documenting the transaction and the projections is essential for us to, defend the company down the road.
Yeah. Steve, wouldn't you also say that consistency in relationship to projections is very, very important? Because as Brian pointed out, having a company that grows at 3% but projecting 10% every year actually undercuts the projections and not the accuracy of the projections, but the value of the projections themselves.
Yeah, Avery, I agree with you 100%. But I've had Department of Labor agents come in and say that every 3 to 4 years, you may want to think about switching your valuation firm to get a new view on whether you're doing the right thing, and get confirmation of what the other valuation firm has been telling you. So
I think the biggest challenge as a trustee in engaging valuation firms and engaging other professionals is that, as Brian said earlier, with the department, everything is hindsight is 2020. And so what ends up happening is that, yes, of course, it's easy to suggest, oh, you should have a different valuation firm. Then if you hire a different valuation firm and they use a slightly different method and you get a different stock price out of that, well, then all of a sudden you have to defend that, ultimately. I think that probably consistency and Steve, and you know this even from my legal years, documentation in relationship to how projections are developed is probably the most critical point. I know that Brian asks when we do diligence, Brian asks who prepared the projections, how are they done? There's a good questioning in relationship to that. Steve, I know that also in your diligence memos, you include that same type of information. So really, it's all about documentation. And naturally, our trustees keep that in their own files too.
Yeah, and really, because there's so much focus on the projections as they relate to initial transactions, I think people don't think as much about the impact and the kind of unintended consequences of projections for ongoing. And that's where I think with this discussion is thinking about the risks of being too conservative, and we do see that. And again, it's our job to adjust the risk factors to say, all right, if if we think these projections are too conservative, we can change them. We don't have to rely on those projections, or we just adjust our what we call company specific risk factors to account for that. But the unintended consequences are yes. I mean, it's a risk of participants who are basically underpaid as they exit. You also have the risk of mature ESOPs that want to remain ESOPs, but are somewhat influencing the value, keeping the value a little bit lower. Again, it's our role to try to not get there and adjust out of that. But if projections are very low, that can impact value. And if their goal is to stay in ESOP, but they're being too conservative in their forecasting, you are an acquisition target. And you might not want to be an acquisition target, but we've seen situations where the companies are very, very conservative in their outlook, and they get a ESOP valuation that's $10 million, and a private equity group or a competitor comes in with a $15-20 million offer, and it's very difficult for the trustee to say no, and in a lot of cases they can't. And so there are those unintended consequences. A lot of times when you see it, or we do get projections that are conservative, it's mature ESOPs that are getting concerned with their repurchase obligation, and maybe in a way trying to manage that a little bit. Again, we adjust, we push back on that. We'll adjust the rates to try to account for that. But I think in general, you get more mature ESOPs they'd rather exceed their budget than miss it, so they tend to be a little bit more conservative. And we just want to caution the companies to not push that too far, because it can lead to some issues. It can lead to litigation. It can lead to challenges going forward. So the most likely scenario is really what we're always looking for.
Right.
Brian, I have an interesting new matter that came up. Just what you said happened, where a company, a valuation firm, conservatively valued the company, and they were using projections. And what happened was someone came in and made an offer, and the offer was like 4 times, 5 times what the most recent valuation was for the ESOP portion of the stock. And a group of retired participants have filed suit saying that their stock was undervalued based upon the fact that clearly this is fair market value, and the valuation firm or the people that prepared the projections didn't do their jobs. And so it's an interesting issue that we're dealing with now.
I would say, Steve and Brian, that probably the best course is education, especially for the CFOs, because what we see a lot of ESOP companies are incredible. And part of the reason why they become incredible is that the former owners, sellers who led the company were conservative. They were conservative in their debt. They were conservative in their projections, right? So that they always accomplished their goals. But as Jeff was explaining, part of being in these companies is educating, sending CFOs to ESOP conferences so they understand. Basically, Brian, when you're describing this, I'm thinking of golfing and hitting it straight up the middle of the fairway, right? You don't want to be so conservative that you're effectively causing the company to be undervalued, but you don't want to be so sales driven and oriented that you're setting up projections that just can't be met because they're stretch goals. And there are a lot of courses that CFOs, controllers, the individuals that would be most involved in setting the projections can attend, so that they can understand the challenges of undervaluing and overvaluing in our world.
Absolutely. And it's tricky because, one of the worst scenarios is when a company projects, let's say 20% growth, and they hit 10% growth. So still strong growth, still a good year. Employees are working harder. But because they projected 20 and only hit 10, the value doesn't move much. And so you get this challenge, this communication issue with the employees, and saying, well, why didn't our stock move? We're up 10%. Well, because your projections were too high. And so that's where we totally understand where CFOs typically would be all right, let's be a little bit more conservative so we don't have those issues. But what we're concerned with, or what, want to again warn people against, is not being overly conservative in those projections because of the risks that can come on the back end of that. And that's what we're seeing. It's not, and our experience isn't a lot of DOL issues with the back end of it. It's more from non-DOL issues, like participants that have exited who have an opinion of value, or like Steve said, are hearing about acquisitions in the industry that, oh my gosh, our value must have been so low. And those types of issues is where I think we're hearing and seeing more of that.
The other thing too is we're seeing a lot of times when we do these ESOP transactions, we issue stock appreciation rights and equity-based consideration to the key people in the company. And one of the things we've seen happen recently is they actually get involved in the valuation, because that impacts what their strike price is going to be for the SARs. And again, you got to be careful, because you want to motivate these people to stay with the company and work hard. If you get a target out there that say you do a performance SAR that they can't hit, well, it's just going to have the opposite effect, and these people are not going to be incentivized. So it even goes further than just concern about the Department of Labor and the IRS. It's how does this impact your employees?
Yeah, guys, just from my perspective as a former participant in an ESOP and an executive there, all of these things that you've said are spot on. I think that education is so important, especially for new ESOPs, because they haven't thought through all of these things. They haven't thought through, okay, if I do this, this is what potentially can happen. Those connections aren't there, and so going out and getting education, helping our clients understand what the issues are, is really, really important. And I'm really glad that you guys have brought all of that up, because I don't think that everybody thinks through that right away, especially if they're not familiar with ESOPs in the past. I do think it's important for clients to understand, though, too, that if they've truly put thought and effort into the projections that they've created, it's their and they're not just, hey, let's add 5% a year or whatever it is to every number, but truly thoughtful projection efforts. It's important, and it's the responsibility of the executive team, I think, to push back and fight for what they believe is right, even if somebody like Brian's firm comes in and says, well, I think you guys are being a little conservative. Sometimes there's reasons for that, and it's important that executives know that they should speak up and push for that. I always thought when we met with the valuation firm and the trustee, I brought a whole team of people along with me. It wasn't just myself and my CFO, but it was operations people and people in other facets of the business that helped us to explain why we were projecting what we were projecting, and why things happened the way that they happened, and why we thought that they were going to turn out either the same or differently moving forward. So I think a lot of what you guys have brought up is spot on.
Fantastic. Well, that's a big one. Very important. Something every ESOP company is going to do every year. So I think hearing about the process, hearing from Brian and Avery and Steve and Jeff, what you've seen in practice, I think that's a topic that we could cover every year. Let's take it somewhere slightly different, but Brian, you had alluded to it, but we'll take it in sort of a different direction. Acquisitive ESOPs. We know that certainly maybe even before, but once the seller debt's paid off, ESOPs are building cash, and candidly, some of them have strategies to be acquisitive. What should ESOP companies think about as they are considering an acquisition from a valuation perspective? And we'll let Avery and Steve kind of play off it on a trustee and legal perspective.
Absolutely, yeah. So we're definitely seeing much more activity, both with existing ESOP companies that are acquiring firms, and on the flip side, ESOPs that are selling to private equity or competitors. on the buy side there, when companies are looking at acquisitions, communication with the trustee is very important. Each trustee is going to be a little different as far as what involvement they want to have in that process. On smaller deals, then typically, the trustee would have, limited involvement. They would want the analysis, of course, done by the company, approved by the board of directors, CFO, outside consultants, whatever, separate from the trustee side that would help through that process. But the important part is to, at least communicate with the trustee early on if you're looking at acquisitions. We have had some situations where, maybe the annual update call is when you hear about an acquisition, and that's a little bit late in the game. Now, luckily, usually they're pretty small acquisitions that don't have a lot of impact, but we still think it's very important that the companies are sharing and updating the trustees when they are considering acquisitions. I don't know if there's a rule of thumb. Avery, Steve, what you've seen in deals, but a lot of times we'll hear if it's 25% of the company's enterprise value, if that's what you're looking at from an acquisition value, that you might, the trustee may want a separate fairness opinion to support that type of transaction. What you're really looking at is that that valuation or that acquisition is we call it accretive. It's basically adding value to the company. It's got to be at least neutral and hopefully adding value. And it's important then to again document that process. How does the valuation metrics and multiples used in the acquisition compared to what your current valuation is? So there may be reasons. Let's say your company is valued at 6 times EBITDA. There may be great reasons why an acquisition would go off at 8 times. The different cost savings or synergies or entering a new market, any of those things, that there's definitely economic cases for that. But again, it's something that you really want to document well and to communicate with the trustee, because at some point, if that premium or that spread is significantly higher, you may be in a situation where it doesn't appear accretive to value, where it's not a comfortable deal from a trustee perspective. So, the main thing is to communicate with the trustee, and then they can make that decision of when they would need to bring in an outside valuation firm to opine on that. Now, they're not going to bring in their valuation firm to do the valuation for the company. Let's say, hey, we're a company, we're looking at acquiring an injection molder. Call the Mr. Trustee and say, hey, we're going to acquire this company. What should we pay for it? The trustee's not going to have their valuation firm do anything for the company because of conflict of interest there. But they may say, okay, continue down the path. Thanks for giving us the heads up. And if you reach a deal, we're going to want to at least have our valuation firm give an opinion that this is accretive or a fair deal. And so that's really more, again, a lot of the just process documentation. Again, each trustee might be a little different of when they want to be more involved or actually have a formal opinion given. But either way, you want to make sure that you're on the front end of that. It plays a little bit back into the projections when companies are too conservative, and if that has an impact on the value, let's say then because the projections or the growth isn't very strong, maybe you're at a 5x EBITDA multiple, but your industry is at 8 and you're trying to acquire. And we've had that situation in the past where maybe a company where the industry is really taken off from a pricing standpoint, but the existing company is pretty conservatively valued based on lower projections, and therefore there's a pretty big gap between fair market value for the existing ESOPs and the acquisition market, and it makes it difficult to go out there and find favorable acquisition targets. So again, it comes down to process communication on that side of it, just to make sure that the trustees are involved.
Brian, I couldn't agree with you more about communications. I think it's so important, whether it's an acquisition or other important issues that come up during the year. Just communicating with the trustee doesn't necessarily mean that they have to be involved in the decision, but I found that they liked that there was an open communication and an open dialogue that went back and forth and kept them up to date with what was going on in the company. One other thing I want to point out is that as we made acquisitions, part of what we had to take into account as well, it's a little more complicated, I think, in an ESOP, just because it's not just about acquiring this other company and taking on some debt service, but what does that do to our cash flow, and what kind of repurchase obligation do we have in front of us, and what additional repurchase obligation are we creating by adding these additional employees to the overall census, and how is, is the whole thing sustainable from a cash flow standpoint after we make the acquisition, when you have additional debt service, additional repurchase obligation, et cetera, et cetera. It was important to evaluate those aspects of the deal as well.
Right. And Jeff, you bring up some really good points there. The DOL and the IRS are really into price protection, floor price protection when you're doing a transaction that could impact the valuation, especially for those people that are close to retirement, or if they were to pass away or become disabled. And so I think that's something that we always consider when we're looking at the company incurring a significant amount of additional debt or risk.
And Steve, I think that ties back to Brian's question, like the 25% rule, like the value of the target company in comparison to the value of the ESOP company. We don't have a hard and fast rule. It's situationally based, but it also goes back to what Jeff said. First of all, it's important to bring the trustee team in just to keep them informed, to see if there's something that needs to be discussed in relationship to this. But the other issue, and you're exactly right about that, is that, well, how much leverage is the company going to take on to do this? Because you're going to have a pool of employees over the next year or so that's going to get paid out. The company is opening itself up to litigation if there's a significant decrease in share price for those individuals who have a short-term planning horizon for retirement.
Yeah, you're exactly right. And, Avery, as you know, when you look at the litigation that's out there, every year, 80 to 90% of the litigation is stock price
Drop.
Yeah,
Right.
stock drop.
That's exactly right. And Jeff, I think that was very valuable. What you were saying is that, there are in an ESOP company, there's a lot of different avenues that you have to look at, including what's going to the lever, what's going to impact the stock price, and what's the potential of the repurchase obligation into the future as you add employees into the ESOP.
Right. And what was interesting is sometimes when we were making some of these acquisitions, is the seller was just like a traditional seller to an ESOP, wanted to know what was going to happen to his employees and how they were going to be treated as part of this. And in a couple of cases, we ended up creating exceptions to our vesting schedules, in that where perhaps we grandfathered people in for prior service with the previous company, and that had an immediate impact on the repurchase obligation that we needed to account for if we were going to go forward.
Exactly.
Great topic. I have one more topic with the time remaining that I wanted to hit on, and it relates to kind of trends around DOL and mediation, and kind of what we're seeing there, and thought I'd turn it over to Steve to maybe kick off this topic as we round out the end of the hour. So Steve, what are you seeing on this topic?
Well, Josh, as you know, with the increase in litigation, plaintiffs' law firms and employees suing companies, what a lot of our clients are doing is they want to put mandatory mediation provisions and also class action waivers in the plan, and the idea being that it's maybe a disincentive for some of these lawsuits that are not as serious, and it makes the plaintiffs' law firms and the participants have to go to another level to try to. It may dissuade them from bringing an action that is not a serious action, and the problem is that you have the Department of Labor that basically takes a position that you've got to be careful not to limit a participant's right to, to contest their benefits and everything. And so once again, just like we had with the indemnification, we got a split in the circuit. And I think it's the 10th and the Third Circuit basically believe that these mandatory arbitration provisions and mandatory class action waivers are not enforceable. And yet we've got the Sixth and the Ninth Circuits going the opposite way, saying that they are enforceable. And what's really interesting is in 2023, the U.S. Supreme Court had the option to take up a case that would resolve this issue, and they declined. So it makes it kind of interesting. And I think, Avery, you and I have discussed this, and Avery, I think, speaking for Avery, I think his approach is, why not put it in there? It's if nothing else, it gives a defense that plaintiff's lawyer may have to overcome.
Yeah, I think Steve, you're exactly right. But to expand on what you just said is that my opinion on this has evolved. Okay. And so over the last 5 years, 5 years ago, I would have told a client when we were designing their plan not to put arbitration in because it would unnecessarily tie their hands in resolving an issue with an employee. But as plaintiff's bar has become much more active, especially in the class action area, I think it's much more beneficial for companies to have arbitration provisions added to their documents, because I think that it does dissuade in certain circumstances what we in the trustee world would label as unfounded lawsuits. Unfortunately, there are law firms out there that troll employees, specifically terminated employees who are not necessarily happy with their companies, and say, basically, let's just sue them and see what happens. And what happens is that the arbitration provisions in a plan, if they're acceptable in their circuit, deflates the ability of bringing a class action suit, and it also deflates the motivation of plaintiff's bar, because you're not going to make a lot of money making a settlement for one plaintiff, right? You want it across the board. So that's a protection. The thing that I would advise, though, is that if you're unsure whether your plan document contains arbitration provisions, I would say that you should talk to your counsel about it, because what you don't want to do, and I actually, in my former life, I had a client who did this, is that after plaintiff's bar started to poke around in their employees, they amended their plan to add the arbitration provision. The issue with that is it's just not a good look. At the end of the day, it's just not a good look. It's like, oh, no, the perspective of the court is that, oh, geez, when you thought you were in trouble, then you did something.
Right.
I think the best approach is that at design phase, when you're forming the ESOP, add the arbitration provision. It can, at this juncture, this is where I'm at. It can only help. I'm not seeing a lot of downside in relationship to arbitration right now. I used to be of the mind that arbitrators wanted to split the baby, which ultimately with arbitration is often true. They're trying to please both sides. But the flip side to that is that if you're arbitrating with one person, it's a lot less costly to insurance and the company. If you're in a lawsuit and you're in a class action suit, it's a lot more expensive.
And I think, Avery, I think a lot of these lawsuits are brought without having done due diligence, so to speak. These plaintiff's attorneys, how much does it cost to file a complaint?
Right.
And I think that going through arbitration, you kind of ferret out some of the issues, which, if you're a plaintiff's lawyer, maybe you're going to sit there and say, well, all of a sudden my upside is not as great as I thought it was, and the risk of losing this. And so, I like the idea of having a chance to present the defense. outside of a court setting where it you know, it can get extremely expensive and maybe unnecessary.
Right, and to tie that all the way back to where we started today, when we were talking about indemnification and insurance, is that $1 million or $2 million of fiduciary insurance, if you're involved in actual litigation as opposed to arbitration, that money burns very, very quickly these days. And it seems like a lot when you get the insurance policy, but if you get involved in especially class action litigation where the court allows it to proceed and all of a sudden you are in production and there's thousands of documents out there, those costs add up very, very quickly.
Good comments. Well, that rounds out the main topics we wanted to talk about today that we're seeing and hearing out there. We've reached the top of the hour. I'm checking the chat box. I don't see any initial questions at this point. I want to thank the panelists for your time today and your insight. I want to thank all the participants for joining. We have another discussion in August, more focused on valuation trends. We might be hearing a little bit more about similar topics and also other topics more focused solely on valuation. So excited about that in the August timeframe. And if there are no questions, we will end the panel, and I hope everyone has a fantastic day.
Thanks,
Thank
Josh.
you.
Thanks, Jack. Everyone.